We said it was going to happen today, and it did happen today. Breaking news out of Portland. The Ninth Circuit, breaking news about Portland, I should say. The Ninth Circuit Court of Appeals has overturned Judge Immergut's order blocking the federalization of the National Guard, which means President Trump can deploy the National Guard into Portland, Oregon. That is a big, big, big deal. Lisa Rubin, MSNBC legal correspondent Lisa Rubin, with us. Am I right? Big, big, big deal?
It is a big deal, and I want to just correct one thing and then explain why functionally it is the same. This is a stay of Judge Immergut's opinion, and that's why it reached the Ninth Circuit as soon as it did, because this is an emergency motion to essentially pause her order. But as a functional matter, you are absolutely correct. It has the function of overturning her order and thereby allowing the president to send the National Guard back onto the streets of Portland. And Katie, I want to read, if I can, just from a little bit of the beginning of this 93-page opinion. It says, after considering the record, and by the record they mean all the factual evidence at this preliminary stage, we conclude that it is likely that the president lawfully exercised his statutory authority under 10 U.S.C. Section 12406. That's the statute we've been referring to as Title 10 when we have conversations about the National Guard deployments, which authorizes the federalization of the National Guard when the president is unable with the regular forces to execute the laws of the United States. And this is the important part. The evidence the president relied on reflects, quote, a colorable assessment of the facts and law within a range of honest judgment. We thus conclude that defendants are likely to succeed on the merits of their appeal, basically saying that when and if a court considers all of the record in this matter is tried and it gets back to an appellate court through an ordinary process where they have full briefing and full evidence, that they still think Donald Trump is likely to prevail there, because he has the discretion to determine, as the president, within a range of honest judgment, when it is reasonable to deploy the Guard.
You and I were talking about last week. When you get into the slippery slope of discretion, when you start ruling when a president can do something that he has the power to do, then you start potentially handcuffing a president of the United States. And this Supreme Court has shown that they don't want any handcuffs whatsoever, even if it's a questionable assertion, even if it's an egregious assertion. They want to make sure the executive is a muscular executive.
And, you know, as I did when you and I talked about this privately, I'll let the viewers in on our behind the scenes.
Please do.
I said to you that, you know, I do see the Supreme Court pushing back, for example, on the first invocation of the Alien Enemies Act, where they essentially said, we have the authority to decide what the law is with deference to the president with respect to his Article 2 powers under the Constitution, particularly in the area of foreign affairs, where the president's powers are at their most robust. Will this Supreme Court, though, cabin the president's authority to decide when something is a rebellion or when regular forces are unable to execute on the laws? You now have what lawyers call a circuit split. We have the Ninth Circuit saying Judge Immergut's order must be stayed. Conversely, we've got the Seventh Circuit saying that the court in Chicago was right to prevent the deployment.
So when should we expect the Supreme Court to weigh in on this?
I think we could expect the Supreme Court to weigh in as soon as this evening, and that's because Chicago owes its response to the Supreme Court by 5 p.m. tonight on Trump's emergency motion to pause what that Seventh Circuit Court has decided, because without a Supreme Court say-so, he can't send the Guard into the streets of Chicago.
Yeah,
right now,
we'll see. We'll see. It's also so unusual and so frothy, because this is just not something we would see another president even try to do.
Correct.
I mean, this is like, it's an area of the law where you didn't think you needed to be so black and white on it, because who would do that was the initial assumption. It's just crazy thinking, crazy talk.
And even before this presidency, we didn't question the idea that a temporary restraining order couldn't be appealed. So just think about that for a second. These are orders that come from lower courts as temporary restraining orders. The prevailing wisdom used to be that those orders weren't even appealable because they were temporary. Now you have two courts saying, essentially, we have the authority to review them because they have the same force as a preliminary injunction. That means they can get through a layer of review that used to be impenetrable for them. It used to be like, you have a TRO, you wipe your hands, you're done.
Yeah, it turns out that, you know, not being super specific has its benefits and has its pitfalls in terms of the Constitution and the exact intention behind it.